We are actually very excited to have this panel. It's a very rare thing that we do have these three panelists in the room at the same time. But they are all considered to be experts in their field, and we are so fortunate to have them with us today. I'm going to ask you to introduce yourself. Let's start with you, Jace, please.
I'm Jace Nair. I'm the CEO of Blind SA. Blind SA is a national disabled people's organization. I also represent the South African Disability Alliance. It's an association of 19 national disabled people's organization, service organization, and parents organizations, as well as the South African Right to Read Coalition that we established in 2009 to advocate for exception and limitation for blind and partially sighted persons. And then, of course, the representative of the World Blind Union in Africa for the Africa-Marrakesh Treaty Committee. And I serve on several advisory committees, the Presidential Working Group on Disabilities, the Minister of Education Advisory Committee on the Education of the Visually Impaired, as well as the Minister of Social Development Advisory Committee on Disability. So I come with a wealth of knowledge and have inputted into copyright and Marrakesh negotiation and discussions, and have traveled widely, particularly through Africa.
That's amazing. That's so governance also is a very big part of the work that you engage in. You referenced Marrakesh just now. I'm going to ask you to unpack it a little bit later on, because it's certainly, in my experience, it's not something that I've had to deal with a lot, but it's something that we all need to understand. Okay, our next panelist, Carlynn, could you please introduce yourself?
My name's Carlynn de Waal-Smit. I am a founder member of the South African Guild of Actors. I am also a shareholder in an actors agency called Contractors, which has been going for 23 years now. I am also a member of the the agents organization called the Personal Managers Association. And I've been in the business for 23 years and am a dancer by trade.
Wow, okay. And in terms of the importance of the discussion today with this group in particular, why is it important that Saga is here?
I do believe that actors and young people don't necessarily understand what the impact is going to be of the legislation, how it will change, for example, the Fourth Industrial Revolution, how it will change their understanding of what happens with audiovisual performers. Saga's mandate is for professional actors, so I can only speak from a point of view looking at performers, audiovisual performers, and the impact of what that means in their everyday.
Very nice. And now everybody, the man who's been making this sexy for many years.
Yeah, my name's Rehad Desai. I'm a returnee from political exile. I left here as a baby with my folks and returned in 1990, and decided after 94 to come back and continue my studies in history, and I came back here, did a master's in history, and then started a PhD and fell into TV work, current affairs journalism, while I was doing the PhD, and decided to give up the PhD and focus on film and TV. We run a small company called Uhuru Productions. The last film we did was about this university, called Everything Must Fall, But the Fees Must Fall struggle, told primarily through the lens of the students at Wits and the Vice Chancellor and so on. So my documentary work began 20 years ago, and I've been instrumental in setting up the Documentary Filmmakers Association, the South African Screen Federation, and now I'm the chairperson currently of the Independent Producers Organisation. We've been involved in the review process of this legislation since 2009. Personally, political level, it's very important for me because I don't believe ideas come from the sky. We build on the ideas and knowledge that is out there, and many visual symbols, if you like, have become part of our everyday language. And if we're constrained in the use of our language, our message, what we seek to convey through our work, and our work then becomes far less competitive on an international stage.
Well, you're actually talking about some constitutional prerogatives there as well, aren't you?
Absolutely. I believe the right to own and create and earn from our work are embedded in our Constitution around the freedom of expression. And that cannot and should not be curtailed for any reason that is not fair.
Get you. Are there anybody here who was involved in the Fees Must Fall action? Nobody? No? All right. Well, to the extent that you researched and covered that in your documentary,
Yeah.
I'm hoping that you can reference some of the work and some of the things that you discovered amongst them where it's relevant to the bills.
Oh, absolutely. Yeah.
Thank you. All right, good. Jace, let's take it back to when were you first involved in the discussions, in the drafting of these bills? When did it come up in your consciousness? Was it interesting? Was it exciting? Did it have a long lead up to the point where you were suddenly involved? Just take us back to how did you find yourself at the center of these discussions?
Okay, firstly, maybe I must make a disclaimer. I do not have any legal training or been in the sphere at all. I'm a disability activist. In 2009, the World Blind Union approached me as being part of the South African National Council for the Blind to say that we are advocating for an international treaty, and we believe that Africa needs to play an important role. What is the position for copyright exceptions and limitations in South Africa? And do you know what the situation in other parts of Africa is?
Sorry, Jace, just to go back to that point about copyright exception. Help us to understand what an exception is.
Okay, the Copyright Act that exists, that all of you are aware, is now so old that you can't even recall its age. Makes provision to protect rights holders. We as blind and partially sighted people are unable to access that print copy, and therefore we need some provision within the legislation to allow us to then copy or reproduce that work so that we can read it. Now, ideally, it should be the author or the rights holders that would make that work accessible for us. And when I talk about accessible for us, you'd find that the common form of reading or writing for a blind person is Braille. And Braille is now over 200 years old. But you have people who are partially sighted or low vision who cannot read the normal print and therefore need large font. And in many instances, they would use font size 16 and 18. And if you're familiar with that, you'll know how big that is for them to read. And then if you take your electronic books, now we can access or read electronic material with screen reading software, which is speech-based, or magnification software. However, we can only use that software if that electronic material is in Word or text. If it is in any other format, we are unable to read it. So therefore, printed works that are now made electronically, we need to have the ability to jump from page to page or chapter or paragraphs, or to search within the document so that we can stop and read.
So, sorry, Jace, just to come in there, you're saying access to that kind of material should be an exception to the copyright provision, so that you can access it and you can use it and read it.
Absolutely.
And you are not then forced to go and pay a huge sum of money to the rights holder to access that.
I think the point is, it's not about paying large sums of money. There maybe two things need to happen. Firstly, to reproduce that book, and I'll just give you a brief, sketch a brief outline. If you take a printed book of about 300 pages, we first have to retype that book, because the software that publishers have been using in the past were not easily convertible. Current software, EPUB 3, allows us for accessibility. So we would need to recapture that old document. Before recapturing the document, maybe I should say, we first got to get the permission or the license from the rights holder. And that in itself has been a challenge in the past. It could take you anything from 3 months to years to get a license. By the time you get it, the book may be out of print or not in popular demand and all those kind of issues. They need to take us to convert that 300-page book roughly 1 month. We would data-type it, we would then have to have a print proofreader and a braille proofreader that will check that the text is correct. Then it will go through an embossing process and then binding. And all that would take about 1 month to do one book. There are very limited capacity in the country for producing braille at that level. Then you have DAISY. DAISY is Digital Access Information System. That is a multimedia format that would allow us to format a document electronically and then have it reproduced into braille, into audio, using text-to-speech, which is artificial or synthetic voice, or human narration that will be recorded and synchronized to the print and the braille. And that would then allow us for easy navigation on a book.
So it's very technology intensive then.
Absolutely.
To convert everything. There was something you mentioned about getting permission from rights holders, and Rehad, I remember seeing footage of you, in fact, in a documentary, and it was one of the many times where you're being arrested, if I remember correctly. But you were talking about the difficulty you had in accessing that footage. What's the story behind that?
So I returned to the country in 1990. We arrive at OR Tambo. We're connecting for a flight to Cape Town, where most of my family are based. And the former Chief Justice Dekan Musaneki is there to meet us. He's my father's lawyer at the time. And the press are there, and they do an interview with us about, how does it feel to come home? What are your plans and so on? And it was a moment. And to access that piece of footage, 30 seconds of that footage, it cost me 700 Rand just to see it in its entirety. To get it delivered, and delivered 700 Rand, but to license it was then, and this is almost 20 years ago, 35,000 Rand for 35 seconds. Now this is from Reuters, I think, or Associated Press. Just another example, the last documentary. Obviously, a lot of media coverage from many places, EWN, ETV, SABC, a lot of online publications and so on. For the 4 minutes that we required from SABC, in total we used about 20 minutes of archive. For the 4 minutes from SABC, 3 minutes from SABC, that cost a total of 180,000 rand. Now, if any of you are trying to make documentaries or thinking about making documentaries, you may know that for an SABC commission, you won't get more than 350,000 rand, and they will own it. So you're looking at astronomical amounts of money to be able to produce a documentary, which you know, if any of you see Netflix, I'm sure most of you in the room have now gone on to Pirate Bay or had illegal copies of something or the other. That you are what we call the digital babes. You've grown up in the digital era of copying and pirating. And personally, I don't have a problem with that because I make my work to be seen. Now, what this new legislation is saying is you will no longer face a potential criminal action for copying anything for personal use. What we've been seeing, if you go to the cinema, is piracy, copying is stealing. What those of us with my political inclination are saying is actually sharing is caring. The growth of the peer-to-peer kingdom, if you like, it is incredibly important. And nobody should be taxing us and making us pay every time we consume a piece of culture. We now have the capacity to put all the world's books into one digital cyber library, where we can all, when I was here and I studied in Zimbabwe before, I used to have to wait weeks for books. I used to have to queue up, sometimes for hours in the library to make my application to get a book from another library, the interlibrary loan service and so on. This legislation is attempting to bring South Africa in line with what's happened in the digital world, the evolution of the digital world, where we can now, if you've got any nous, access almost anything. And I knew the game was over. Another little story, en route to Cape Town, driving there for my Christmas holiday with my 10-year-old son 12 years ago, when he got a phone call from a friend who wanted to access a song. And he gave him, you know, from the top of his head, instructions for about a minute of how to get that song, right? Now, really, you know, it's up to you, the young people, to tell these gatekeepers, the older generation, who are trying, you know, the big publishing companies, the fact that, you know, actually 90% of all TV produced in the world today is produced by 15 big studios. They dominate our TV screens internationally. And they are trying to protect that. And, you know, the reason why you've been seeing these ads and these campaigns in South Africa, which you don't see in neighbouring Southern African countries, is because they believe South Africa is still an important market for them commercially, that they need to protect at all costs. So they've sent their people from the big studios here to lobby. They've sent their people from the big publishing companies here to lobby our government. We are net importers of books, of movies, and a whole number of other things which a very few people in the world make a lot of money from. And they do that by restricting the access as much as they can to those works. We've got to fight for, I believe, a new world order where we can access this critically important cultural activity that's happening around us if we are truly to become part and parcel of the world as global citizens.
Now, you say that within the bill there is an enabling aspect to the bill that says, with this, people can now access so much more information, and it's not necessarily the prescriptive process of going to acquire the rights as Jace described. Now, surely in principle there has to be some kind of a line drawn as well.
Absolutely, for people like me, because I run a business. It's a business model.
Yeah.
We make TV programming and we try and sell it around the world. We
Right.
try to make it as best as it can be in order for it to be sold.
Mm-hmm.
South Africa is just one market. Now, the fairness, whether it's fair dealing or fair use, this is what the legislation is saying. We need to move to a fair use system where these exceptions are in place to the copyright. So I can use, essentially, once this legislation's passed, and we are lobbying the President to pass it, despite all this opposition that's being led from the big publishing companies and studios around the world. I can use that material if the legislation is passed, if it doesn't undermine the inherent market value of the work that I'm taking from.
Okay, that's an important distinction.
Right.
Eh?
Yeah. So for you as students, it will be illegal for you under this new legislation, assuming it's passed, for you to copy something and then sell it. To copy my work and sell it on without these exceptions now, or fairness.
So and you would have to bring the action.
Yeah. Well, I would have to, if I felt that my work was being pirated and I was opposed to the pirating, I'm not always.
Sure.
Then I could report it to the police and say, listen, this is, but why? Why do we need these exceptions? I mean, has anybody seen the Trevor Noah Daily Show? Yeah. Now you couldn't do that in South Africa because you couldn't use all those clips that they use without paying astronomical sums or having to clear them. And they're doing clips from the day before. They're keeping it very current. Just the legal process wouldn't allow you to do it, never mind the monetary aspects of it.
That's
so
true.
It frees us up to create based on, one, are you transforming is it a transformative use? So are you transforming that song? Are you giving it a different meaning? Are you giving that image a different meaning through the way you're placing images next to it? Are you using it to critique? Are you using it for literary purposes?
Parody.
Parody. There's a whole number of exceptions. So, it would provide the ability for the Jace to turn my work into an audio format without him having to pay me.
Sure.
And this is very important.
Absolutely, because that'll be a justifiable use categorized as a fair use exception. Carlynn, two questions for you. When did you first come across the bill? How were you involved in it? And more importantly, what will this bill mean for actors?
So I first got wind of the bills in 2012. Saga had just become a member of FIA, the International Federation for Actors. And the first time I realized that there could be ways for actors to earn royalties or residuals or whatever for their work.
What is FIA?
International Actors Federation. It is the global body of all actors, unions and guilds and associations around the world. So I think it's over 70 odd countries that are members. From the United States, Canada, Australia, New Zealand, Japan, Denmark, Sweden, a whole bunch. So basically and asking the question, like, how come we don't have the ability to collect, the ability for actors to earn from their work? So the DTI actually held a conference about 2 weeks after I got back from the Federation for International Actors Conference, and was the first time that I heard that there was some kind of revision that was being done to the copyright bill. So that was the first time that I got wind of it. We specifically were able to engage with it in better forms and more of an engaging process around about 2015, when the DTI was looking at submissions and feedback and some kind of comment on what they'd already put out. So there are two bills currently. The one is the Copyright Amendment Bill, and the other one is the Performance Protection Amendment Bill. So the Performance Protection Amendment Bill is actually that's our bill as actors. I mean, that is created specifically for us. The Copyright Amendment Bill has many provisions that Jace and Rehad are talking about. When it comes to actors, it makes provision one for some kind of dispute resolution. So if there's an argument or a dispute around the use of the image and whether people are owed money, there's actually a mechanism for you to be able to deal with that dispute so that it doesn't have to go into large legislative issues and courts and those kinds of things. The other thing that it makes provision for is for collective management. So a CMO is a collective management organization which basically collects money for the use of work. So everybody would, be aware of, there are Dalro, for example, is a CMO in South Africa, Samro.
Dalro is for
literature and plays.
Samro's for musicians.
Correct. So in South Africa currently we do not have any collective management organization for any audio visual. So nothing that you have seen on screen in terms of the payment for actors exists currently.
Okay, that's a huge point to make. You are saying that currently there is no right, statutory right or otherwise, for any actor to perform in a TV series, a soapy, a movie, and to be able to claim thereafter every time that a production is licensed around the world or broadcast or put onto the internet at all.
Nobody gets paid a cent. So currently the way that it works is as an actor, I get cast in let's say it's a movie, and I go onto set and I get paid to work for the day. In South Africa, that's the money you get paid, and you go, thank you very much, and you go home. And that's the only money you ever see for your work. The producers, the distributors, whoever, they can sell it, they can license it, they can put it on the internet, they can do whatever they like forever, and you don't get another penny. That's the current status. The current Copyright Amendment, Performance Protection Act is from 1967, before we actually had television. So you can see, I think television came in 1976.
Yep.
So you can see that, you know, not only many years later, the entire legislation was defunct.
Yeah.
It didn't actually serve any purpose. Internationally, what happens is that people get paid for being on set, and then they get paid for the use of their image, because they own their image. Currently, actors do not own their image in South Africa.
That's another good point. Let's just reflect on that for a minute. You were saying that royalties for actors exists everywhere else in the world.
Most places.
No.
Most places.
Most places.
Not everywhere.
Not everywhere.
That's what
no?
I'm saying. Most
Yeah.
places. Some of them
Well,
are.
not most places.
Some of them are statutory, and
Yeah.
some of them are through collective bargaining.
Most advanced capitalist economies.
Yes.
So Europe, Australia, Canada,
Yeah.
Yeah.
America.
Let's also explore that distinction. You were saying that some royalties are collected because statute has been created to allow that,
Correct.
and in other areas, territories, you might have collective bargaining agreements
Correct.
that protect the right for actors to collect.
Yeah.
All right. So
Well, we have the same. So
Yeah.
I'm always very interested in selling to New Zealand, Canada, and Scandinavian countries.
Mhm.
Why? Because I'll get director's royalties as a documentary director. I get royalties for music that I've bought and owned. Reproduction, you know, if the universities reproduce it or schools use it. There's a whole set of royalties that come my way and have been very useful at times.
Mm.
You know, when times are hard, and you know, if you're an artist, an active artist, they often are, and these are critical. And the other key thing, I think, in terms of owning the image of the actor, is there was this one case where some American production house made this film ostensibly about the Bible, and produced, got this quite big actress involved playing, I think, Mary or someone. And it was a intrinsically Islamophobic piece. It was inciting, really, hatred against Muslims. And she took the studio to court, and she won. She said, actually, this is not what I signed up for. You're using my image to incite hatred, sectarianism, religious sectarianism, and I am now arguing that you can no longer use my image in your film, and she won.
There is also that aspect to it, which in terms of the legislation is the moral right. So one part of it is the right to own my image. The other part of it is a moral right, which basically means that you cannot defame, you cannot basically change my image in any way that is going to be harmful to my reputation.
Distort or
Whatever. I mean, that would be one of those situations where you basically are taking away my right to agree to do a project of X, and you've manipulated it into project Y.
And now the moral right, as you describe it, is a feature of this bill.
Correct.
This is important. Now, I would imagine, also, if I have to look at Jace and the unique perspective he has in the bills, for me that would be a moral justification as well, to say why the bill needs to be updated. But fill us in here, Jace. Where is the argument against the bill in terms of your perspective? Why would somebody say, no, Jace is taking advantage of a situation here. I know he's blind, but surely somebody can read the damn thing to him. So what are people saying?
I think in order to address the question that you raised, we first need to look at what are the legal frameworks. The bill is fundamentally a human right instrument. Nobody is doing me a favor, and therefore it is my right to have access to information.
Sure.
And in order to have that right, we have firstly the international instrument, which is the United Nations Convention on the Rights of Persons with Disability. In several articles, specifically obligates the state parties to provide access to information in an accessible format. I mentioned earlier the Marrakesh Treaty, which we'll talk about later. Within South Africa, we have the Bill of Rights in our constitution that guarantees me that right, as well as the white paper on the rights of persons with disability. But the immediate tool that governs copyright prevents me from having that access. So therefore, the Copyright Amendment Bill gives me that leverage to say, we would like to have access to that material on the same day, the same price. We are willing to pay the same price that you would walk into Exclusive Books to buy that book. Why should I be paying more for that, or why should I be producing that book itself? So therefore, the moral right exists in terms of that human right itself.
Sure.
I mean, just on that. I mean, I'll tell another story, but I did want to ask. Now, how many people in the room are doing theatre? It's quite a lot, and
love you guys.
and TV. How many people are doing TV?
Brilliant.
And then arts and culture management. There's a good, because assuming this bill gets passed, there's going to be a lot of work that we're going to really need to drill down on in terms of the regulations and the collection management organisations. Who are these collection management organisations been lobbying against the bill? I mean, they are not run by their own members. They are not democratically run, and that's why we need this bill. They need to be regulated and to be acting in the interest of the artists that they're supposed to be representing.
I think that's a good point. Let's just take it a step back on CMOs and describe who they are, what they are, how are they mandated, what are their functions. Just describe that process for us, because this is one of the biggest elements for, certainly for actors in the copyright bill.
I mean, basically, they are there to ensure that. So, I work around the corner in the offices of SAMRO, which is the music rights organisation, which collects royalties for musicians. It's a huge office. It's a huge building, so my office is quite small. It's an expensive building. Recently, they wasted 50 million rand on an investment into Dubai. Now, where do they get the money to buy the office? Where do they get the money to make the 50 million rand investment into Dubai? Who makes the decision to buy the office, which isn't making them money? I think they're losing money on that office. They lost the 50 million rand. It's on all the uncollected royalties, unclaimed royalties of the musicians. Okay? That they are not informing musicians out there of how to make sure you put your claim in, that the road shows that need every musician that ever produces anything needs to be told of how and instructed how to register their music and how to register their reproductive rights and mechanical rights and so on and so forth. And so we've got these collection management organisations, not only in South Africa, but around the world, that are very, very rich. And they become self-serving. And they pay their CEOs and CFOs and board members extortionate amounts of money. Okay? And they're living off the backs of the creative work of artists who are ill-informed and not knowledgeable about their rights.
So I mean, basically, there are reproductive rights, right? So when music is reproduced and when music is played, we've just now had the thing in South Africa with needle time as part of this copyright review process. So musicians are supposed to be paid the money that the radio stations have got to clock up
when they play this music, how often they play this music, what time they play this music, to work out what the needle time is owed to ultimately the musician. Now, sorry, you want to come in?
Yes, Jace?
No.
Yeah. So, and then there's the mechanical rights, the DVDs and use of music in TV shows, theatre shows, and so on and so forth. So these are all very important. I mean, I can't tell you much more than that, but just to, I did want to come and say that, you know, until these organisations are run and controlled by the members, and ours needs to be, and are in sync and knowledgeable and in collecting, have access to the databases around the world which tell us what programs are being played on what stations and what music's being played on what stations and so on, what scripts are being used, you need to register your scripts and so on, then we're lost as a creative community. But the key thing here for me is that we begin to work out exactly how much do we need to run a collection management organisation effectively. What are the skills? How are the members involved in the decision making? And it's particularly the big decisions, the policy decisions, when it comes to investment of our monies and so on. How do we make sure that everybody's on board and knows how to register their music and their artistic works and so on? So this is a big task. And also, how do we work out the royalties? Now, I'm a producer. I have done drama, so I have an active need to know and to begin to negotiate with the actors. Are we having a separate wing of the collective management organisation for actors, or are they having their own collective management organisation?
Let's pass that to Carlynn, in fact.
Because we don't want the Department of Trade and Industry setting on their own, in their own little corner, without deep consultation, what these royalties and so on should be and how they should be paid out.
I think the important thing for me is that Saga specifically has been researching what happens when it comes to audio-visual use and how it works internationally on the exploitation of audio-visual performers and how that is collected. So we have done research in Canada, we've done research in the UK, in Denmark, in Sweden, to see what those systems are, so that when we have that provision, that we come from an informed point of view. Collective management for musicians is very different from collective management for audiovisual. And my opinion is we can't put them all in one basket. You have to deal with who the right owners are. Each performer has the right to own their image, and they will exploit it, because that's the reason why you get onto camera in the first place, because you want your work to go out there. But how that needs to be collected and what the terms are under which that works is really important for us to have across the board. And we have to consult with the DTI, and the DTI has to consult with us. And we have to have a very real say in who creates the rules for the CMO for actors. I don't want a musician to create the rules for an actor. I want actors to create the rules for actors. I don't want, producers to tell actors what we must charge. Actors need to be able to be part of that conversation. So I think it's really important that we realize who the parties are that are eligible for payment for their work, and how are those individual sectors going to be able to, one, monitor exactly where their work is, what is the formula, how are they collected, and how are they, most importantly, how are they distributed to the actors. And that process for me, I think, is intrinsic, and it has to be transparent.
I'm going to come to you now, Jace. I'm something just I'd like to add on this. It actually made me a little sad when I was researching this to think of if you have to look at the nature of the mistakes made by CMOs in this country up to this point, you would, if you're a cynical person like I am, you would say that they're actually quite typical. It was a horrible failure of governance. You already have a board sitting at the top of this organization. You already have a system by which you collect and you are meant to distribute. Where is that money? How could we fail at something so basic if you, as the performer, as the musician in this case, you had a right to vote and determine who sits at that board? Were you not holding your board accountable? Were you not asking them the questions about transparency and governance that you should have been asking in the first place? And now when your money gets stolen, you don't know what to do anymore. So obviously the question of CMOs, especially in a new territory now being proposed for actors, is going to be looked at very carefully, because when we get it wrong and we have an opportunity to create legislation to put it right, you are not going to miss the opportunity, which is where we are right now. I just wanted to ask, in terms of the numbers of actors who are in a certain production, in a scene, on screen, they're the two main actors, they're in the front and they're sitting at the table and they're having a lovely chat and they carry the story. I imagine that they will be paid royalties on the exploitation of the work. Now, I see in the background, there's a waiter walking and he's pouring wine and then he disappears into the back. Is he going to get paid royalties as well?
No, basically what you have is there will have to be a very clear distinction within the regulations in terms of who it is collected for and who it's not collected for.
Mm-hmm.
The one thing from the discussions that have already happened that Saga's been involved with the DTI is background performers, or extras as some people know them, are not eligible for collective management or for earning rights and royalties.
Yeah.
But people who are intrinsic to the scene, people who have a character, people who have something to say. So I come in, I'm a waiter, I come and have a conversation with you about the water, how great it is, would you like another something, is it possible to A, B, and C? I'm intrinsic now, I'm part of the story. I need to get paid. I'm not going to get paid the same as you as the lead actor. Because I share this amount of screen time and you share episode after episode after episode. And just with some kind of an idea of how things work internationally, that the amount of screen time you have, very often in some of the processes, is the clue as to the nature of how much you earn.
Okay.
So in the UK, there's a lady who sits in front of a screen and she has a list and she goes, okay, so you're on screen, quite a lot, you're a 3 because you get more money. Okay, so you're in and out the scene, you're kind of like maybe a cameo. All right, so maybe you're a 2. And then you come in hardly on screen, but you are still intrinsic to the story, so you're a 1.
And they would do this for a series, for a movie,
for everything, so that they understand that your contribution to the product will be your reward for the product.
Jace, you had a comment earlier, and as you get into that, also try and cover the question that I have about, is the bill about, is there enough in the bill that secures governance? Because I know that's an area you're particularly strong at, and it's something that we just covered in the discussion about CMOs, where there was a distinct failure of governance. You can pick that up.
Yeah. Okay, firstly I just wanted to go back to the earlier question you raised about what is the objection around, or the objectors. The initial reason that was put forward was to the effect that you got a group of people now and you're going to give them access to your work, they could start to pirate that work. And we're saying, but that is just a perception you have, a fear you have, because we are all law-abiding citizens. And if there are legislation in the country around that, then we might be prosecuted for that.
Sure.
And the second one was that the control, how do you control the distribution of this material? And we're saying again, there is ways of safeguarding those through watermark and using technical protective measures, TPMs, and things like that. And then the third one was, we're going to open it to people with disabilities. Isn't it going to be too much of a loss of income for us? And we're saying, but you know, at the moment, the vast majority of people with disabilities are low-income earners. What impact is that going to be on your market share? Rather, why don't you work with us to see how can you create a niche market for yourself from us by creating these accessible formats. Now, I spoke earlier around in a blind and partially sighted people, but the bill also says that persons who are dyslexic, for instance, have a difficulty in reading, can get exceptions through this amendment. Persons who are physically disabled and unable to turn the book of a page can have access to alternative formats. Similarly, with persons who have very low literacy skills or levels would be able then to have adaptation to enable them to be able to do that. You raised the issue of governance. Yes, for us as a sector, we are also concerned, and we believe very strongly that the creators of the works need to be compensated, they need to be rewarded. Yeah. If not, we're going to stifle innovation and the generation of more work. So, through the World Intellectual Property Organization, WIPO, they've created several mechanisms. Firstly, the bill puts in place what is called an authorized entity. So an authorized entity has to be recognized within the country as an organization, an institution that takes responsibility for ensuring that whatever they produce, they can account for its production. Whatever they produce, they can account for its distribution. The titles, the author, and the format of its accessibility is then recorded so that that can be then made available through the DTI and the WIPO computer database system that they created through a specific project under the Accessible Book Consortium that will track every book that's then made accessible anywhere in the world. And then we now, for instance, if my organization becomes an authorized entity, we would need to keep those kind of records. And we would be producing that book not for resale, but for use, for individual use, for persons. The cost of the master production is expensive because to produce one 300-page book in Braille would cost us somewhere in the region of about 26,000 rand. But to reproduce that master in terms of a duplicate copy would cost us about 300 rand. So the mechanisms to ensure governance, to ensure protection, we believe is there. It could be included in regulations to strengthen the perception or the fears that rights holders may have that we may become the next pirate alliance.
Could I just come back on this, because it is important. I mean, I've been trained as an historian, and I once went to a very illuminating seminar from an overseas scholar here at Wits, who explained how development basically happens from east to west, the trades with the winds of trade.
Mm-hmm.
And it begins with the first known big civilization, the Chinese civilization, where they invent printing presses and a whole number of other things.
Mm.
And then it's built upon by the Arabian Empire, and the mathematics and medicine and so on and so forth. And the Industrial Revolution is premised on all those innovations that happened in China and Arabia, the Arabian Peninsula, hundreds of years before that. And then the Industrial Revolution in the UK, they begin to patent and copyright everything. But what happens is you've got emerging economies in Germany and America who now want their own industrial revolutions and say, to hell with copyright, actually. We're going to use this. This is a key tool for our own development. Now, let's take this back down to you as individuals, as creators in this institution. Now, if you, assuming this legislation is passed, and again, we are going to fight for it to be passed, you will be able to do a film based on all previous works, or let's say, and you've got a theme, how black young rural women are represented in film. You can take clips and you can make a critical discourse from it and produce that film. You can do it on anything. You know, how many people of Zulu ethnicity in the room? Right, you will know how in this province Zulu migrant workers are represented, the discourse around that, okay? And that gets reflected in our theatre, in our art, in our books and so on. Maybe you're interested in doing something on that. You'll be free to do that. And you won't have to pay actors' royalties because there's the exception, okay? You're using it for critical discourse or parody and so on. The same with theatre pieces. You know, is there a record of the theatre plays of the top leading playwrights in this country who historically have been white? What are their themes and so on? And I've actually been to a number of festivals where the jurisdiction allows the festival has actually paid someone for 2 months to sit in an archive and put a film together on fallen women in audiovisual history in British cinema. Or, it's a massive array of freedom that we require in order to really force through development of our arts and culture sector. It's a key tool and it cannot be underestimated.
Yeah, I agree. So you're saying that as things stand, when you want to make that movie, you're going to be paying a lot of money to access that footage. But with the bills, and hopefully when the president signs this off, it will create a greater scope for free use.
If you've got the nous
Yep.
to edit and to direct a piece, you don't have to go out and shoot anything. If you're in film and TV now, okay? You can make your mark on the basis of transforming previous works to say something about those previous works and about this country in the process.
Mm.
And I think that is critical for any artist's development. You can't, that's why it's so damn expensive and hard to get into this university, because the way our society and systems are set up is they say this is only for the privileged few of those who can afford it. We've got the opportunity to be here, to access these libraries, to access these works and so on, and to build on previous people's knowledge. We've got to now, because you are digital babes, you know how to access this information, these works and so on, and get out there and start using it. Because I'm pretty sure in a year and a half time at the maximum when this bill is finally passed or finally in place, or its regulations, you can come out with something and say, this is me.
Jace, you'd like to add to that?
Yeah.
Now, I just wanted to demonstrate two things. Firstly, I'd like maybe all of you just to indulge me for a couple of moments. Can I ask you to close your eyes? And I want you to imagine you're walking into your local library, or you're walking into a bookstore. And then I want you to stretch your hands out and pick up that bestseller, The Gangster State, by Myberg. I want you to open it to page 15. Go down to paragraph 3. Can you read it? Tens of thousands of us are faced in that situation on a daily basis. In this country, currently, less than 0.5% of published works is available in accessible format. And access to information enhances literacy, education, skills, qualification, employment, social justice, and gives you economic independence. Without that access to information, you are marginalized as being the poorest of the poor. You don't access tertiary education. Currently in our schools, we have 22 schools for the blind in South Africa. Only the workbooks from grades 1 to 4 and from grades 8 to 12 are available in an accessible format. There are no CAPS textbooks. There are very little prescribed books or recreational books. How are we expecting these learners to perform and to join you at this institution? They have to struggle through that odds. So this bill and the ratification of the Marrakesh Treaty, South Africa ratifies the Marrakesh Treaty, almost immediately we would have access to over 500,000 accessible titles in English, which we don't currently have. And there are tens of other thousands of other language books that we can have access to. So the importance of the President signing this bill, bringing it into law, and ratifying the Marrakesh Treaty is immeasurable. And therefore we would urge you to be our advocates and continue to campaign so that this marginalized sector of the community can also be brought on the same level playing field as you are. So we can compete equally with you. We're not asking for any extras, but just give us that what is due to us.
What is the Marrakesh Treaty? Let's go there. Jace, we said we were going to reference that early on.
Way back in 2008, the World Blind Union went to WIPO to say,
The World International Property.
yeah, the World Intellectual Property Organization.
Yep.
It is part of the World Trade Organization and a UN agency. And they went around and they said there are almost 285 million blind people in the world. And blind people are limited to access to information. In the developed world, it ranges between 1 to 5% of published works that is available. In other developing countries, in most parts of Africa, it's less than 0.5%. So they said, we need some sort of instrument that would help us to ensure that rights holders make their works available in accessible format. Brazil, Uruguay, and those countries then decided to sponsor a treaty. It went up to WIPO. The USA and EU were against the idea of a treaty. They wanted a voluntary agreement. And we're saying that we've been having a voluntary agreement for hundreds of years, and it hasn't given us anything. What guarantee we're going to get that you are now saying you're going to give us a voluntary agreement. We want a treaty. And that's how the treaty is saying. Africa then developed what is called the Treaty for the Visually Impaired and said, in addition to the visually impaired, what about libraries? What about education? What about research? The northern countries are taking huge GDP from us, away from us. And they said we need something that would allow, firstly, that all works, when it's published, should be made accessible on the same day, the same time, at the same price. Secondly, that it should allow for cross-border exchange. That means, and I'll give you an example, we in South Africa many years ago produced the biography Long Walk to Freedom in Braille. South African blind people were able to read it, but we weren't able to share it with the English world because they were not allowed to import or export books into our country. The Marrakesh Treaty now, the other example I wanted to give you is, I'm sure all of you have read the Harry Potter series. And the Harry Potter series was produced by 8 different countries. Can you imagine the duplication cost in 8 countries? If it was produced in one country and it was then able to cross borders, and the other 7 countries produced other books, we would have more books on our shelves. So the treaty then makes provision for cross-border exchange. In the same vein, it then allows for importation or exportation, provided countries have ratified the treaty. So that if an accessible book is available in Zimbabwe, we can import it into this country freely. Then the other important point is, many of you are familiar with Kindle and other reading devices. They all have electronic locks. Even software that we use to read, like our JAWS speech or magic magnification, has electronic locks, which limits or disables us from using that product effectively. The Marrakesh Treaty and the bill allows us to circumvent that TPM so that we can have access to that product for personal use. So the Marrakesh Treaty currently has been ratified by 82 countries. South Africa has not ratified, yet we played a leading role in the negotiations. And our surrounding neighboring countries, like Lesotho, like Malawi, like Botswana, like Zimbabwe, have all ratified.
Wow.
So it is time that South Africa ratified so that we can benefit from those hundreds of thousands of books that's available in all sorts of accessible formats.
Yeah, we need that. With 12 minutes to go, Rehad, I'm going to give you 6 of them, 6 of the best. I would like you to cover, for the benefit of our audience, the perspective of the fees must fall activists and what the bill might be able to do for them, because they have specific concerns about it, and that's the bedrock of their activism was about, we can't afford the education that we need in order to take the role of the youth leadership forward. And Carlynn, with your 6 minutes, describe to us the process of regulations that Jace referenced earlier. What will we achieve with regulations? When does it come in the process? And what will you be asking for in the process of regulations?
Yeah. Well, I think one example which illustrates the wider point about the decolonisation of education is, I was in Zimbabwe for a while, for a couple of years, and got to know this family, and this one young boy was very wayward, very bright, and 10 years, 15 years after I'd left the country, he really very excited about doing film and TV and begged me to come and get involved in TV production. We were doing a drama series at the time with feminist undertones about single women who have children or want children, and that their struggles around their relationships with men and other women. And he said, I told him what we're doing, and he turned around, no experience in film or TV or any training. Have you seen this? Have you seen that? Have you seen? I said, no. He said, I'll bring it to you tomorrow. I've got it all on CDs or whatever, DVDs. He was able to download all that stuff because they had fast internet in Zimbabwe long before we did.
Yeah.
And able to see everything that's good, that's being produced, has a meaning. So, you know, he had a library, so one, data must fall.
Yep.
You know, the rights to information is critical. Without fast internet, you're not going to get these really heavy files, especially audio-visual stuff. Now, I'm certain that you know, most known plays around the world have probably been filmed. Certainly the stuff that you're studying in terms of your theatre studies, including a lot of the good African stuff, good stuff from the global south. You know, without access to stories, which I think is the best, you know, I'm convinced we learn first and foremost through stories and storytelling. We're not going to be able to build on and develop our own aesthetic, our own voice, our own identity as cultural practitioners, as screenwriters, as script writers, as novelists, as directors, as editors, as actors. We really have to gain access to it. That's the starting point before we can begin to make it appropriate and useful for our own purposes. Now, it's one thing to have a digital copy somewhere on an external drive. It's another to have the hard copy, you know, so which you can read when you're on a train or somewhere where there's no internet and so on. You know, once I think the Act will, if it's passed, give the impetus to bring down the huge tax on books. The Act will allow libraries to access all this material through collective licenses system, which is being proposed much more cheaply. We know this university's library's budget has been under consistent attack for 20 years now, and the library's does not compare. This library does not compare to Oxford, to Cambridge, to Harvard, to Yale. You internationally are getting a second-class education. That is the reality. And we've got to undermine that in whatever way we can. Now, for me, decolonisation is charting our own path and making sure that not only are we able to consume what's being done around the world with our neighbouring countries and the wider continent, but you know, begin to build on it and actively transform it for our own, with our own sensibility. And we have a sensibility in South Africa, so you know, we can have all these curriculum committees for every department, and I think there's 40 such committees at this university looking at decolonisation. But you know, without the real stuff is not what you hear from a lecturer. It's from what information that you piece together the perspectives that you piece together from your own research.
Critical analysis.
Yeah, and that we have to have access to that. Without it, I really do believe we're going to continue to be playing second fiddle to innovators, to creatives, in the creative economy around the world. And there is an economy, but it's, why are I don't think it's a coincidence that they went ahead without any copyright permissions to produce all the classics that existed in the world in America, right? And produce those books cheaply and to make them cheaply available for people. And then there is no relationship between that and the strength of the American film industry.
Absolutely.
Right?
Absolutely.
There is a relationship, a direct relationship between the strength of American documentary, North American documentary, and fair use. Fair use has been in operation in America for 40 years. It was the first country to introduce it, to make this legal.
Yeah.
What they've been doing illegally for decades before, in terms of these world international legal intellectual property regimes, legal regimes around the world. So, yeah, we've got to wake up, smell the coffee, and fight for what is ours, what is our right. And our right is to consume culture, to consume literature, to consume books, and to make our own sense of them and to develop on them. Without them, we're lost.
Yeah. Carlynn, your point about regulations, and the reason I believe it's important to end with that is because the theme for the discussion tonight is about how do we position the law within our industry, and that's what we're trying to understand. So where did this law come from? What is the process of the law that has to be followed? And we are at the point now where most of the activism, I think, went into the early stages. A lot of the interrogation of the bills, the consequences thereof, the impact, the economic assessments have been done, even though many would claim that they haven't. The fact is, and just to give this brief context, is that the bills were proposed by the DTI. They then followed the process into the Parliamentary Portfolio Committee of the DTI, which looked in depth at both the bills and what they are likely to do, whether they would meet their objectives. With their proposals, it went then to the National Assembly. And in November last year, the National Assembly adopted both these bills. It was from the National Assembly that both the bills then went to the final step, which is the National Council of Provinces, which adopted both the bills in March. Where do we sit now? Well, we are hoping that the President will sign the bills in order to achieve all the things that our panelists spoke about today. Let's say tomorrow he signs the bills, Carlynn, what happens then?
We'll have a party.
In here.
Right here.
That's the first thing. Basically, the creating the framework and looking at the legislation is imperative. But that means nothing unless it can actually get down to making a difference to each individual the way it was intended. So in order to do that, you take legalese and you need a process to take the legalese to be able to implement it. So those are the regulations. So when we're looking at this piece of legislation and how that's going to work in a practical sense, there are going to be regulations that say you're going to do it this way and it's going to work like this, and these are the things that you need to take into account, etc., etc. So with all of the avenues and the amendments that basically are being proposed, you will need to have a set of regulations that will basically take the legalese and put it into some kind of framework. Once you have that framework, which would be the regulations, and it's going to be a bun fight, coming up with where the legislation is and how you want it to be implemented in your specific sphere. So, as actors, we're going to ensure that, you know, we can have all of the Beijing Treaty provisions clearly define in how we're going to collect. So that's going to be a big thing for Saga to go, okay, so how does the regulation make provision to be able to collect? How is that going to translate into, this is a physical thing that we're going to do, and therefore this is how I end up getting my money.
Okay.
So the regulations are going to give the framework for implementation.
Oh, okay, of the Act, the amended Act.
Yeah.
All right.
In a practical sense, though.
Yeah.
Not just it's going to implement the law. It's going to take the law, the regulation of it, the implementation of it in terms of what it's expected to do, and make it practical. So that industry has to be involved in how the regulations are going to be translated into action.
Practice.
And practice, and there's going to be a large amount of education that is going to be required for people to understand how this landscape is going to shift and change. So just to, you know, Rehad was speaking earlier about, you know, the musicians not knowing how to claim or how to do whatever. That will be the responsibility of the regulations going into some kind of implementation of that information is going to be vital in order for the legislation to have true effect.
Yeah. We will need regulatory agencies which are manned by people who have an interest in making sure the collection management organisations do their work and do it properly. I mean, one thing, just two quick things. I mean, part of the problem with actors is with the emergence and rise, very dramatic rise over the last 15 years of cable TV, pay TV, and unlimited repeats and so on. What have they sought to do, these big operators like Mnet and DSTV? Stop royalties. Actors don't get royalties from Mnet.
In August 2004, specifically, because I was in that meeting with the then CEO of Mnet when they pulled it out of their contract.
So now we're going to streaming. Netflix. These are all big developments, technological developments, which are game changers. And unless creatives begin to actually organise, get self-organised and demand legislation and enforce the rights that come from the legislation, we're going to have a much poorer creative sector for it. So, people say, well, oh, you guys, you're with Google, you're with Amazon or whatever, YouTube, you're with the big tech giants because you're saying these guys have a business model which is dependent on having as much content on these platforms as possible, freely available. We've got to organise to ensure that our work that goes on to YouTube or other platforms is remunerated properly. That's going to be a battle. This is the beginning of, I think, this legislation, the self-organisation around the collection, our own collection management organisations, which are run and controlled by ourselves, to begin to fight the bigger beasts, the bigger battles out there.
But I think the advantage for specifically for actors is that for the first time we will have the right to be able to collect for that. So because of the Jace was speaking about the Marrakesh Treaty, which is so much ingrained in disability. We, as performers, we have the Beijing Treaty, which basically allows us to be able to collect on the various media. So yes, it's great to say we're moving into all the streaming. This legislation will give us the right to earn from that. In terms of actors.
Will it give us the right to negotiate contractual arrangements, how much we earn, is dependent on how well we're organised. I
It's
don't know,
also-
do people know Yuzo? Right, so it's broke ground in South Africa, probably one of the, post-94 period, the most successful local drama series to hit South African screens, owned by SABC, but a brainchild of a local production company. That's just been sold to streaming. The local producer said, we had no idea that this is happening. So how are the royalties that were entrenched with SABC for actors and writers and so on now going to be paid for by the streaming companies? So this is another thing that the bill is important for, because works that the creator says, well, listen, you're not doing anything with it, you're not utilising any market value from it, I have the right now to contract to take it back. Or this work is very successful 25 years on, we have now the right to renegotiate that contract to make sure that the royalties are in line with the success and popularity of the piece.
And
So if you do produce something
Yep.
which is a classic and becomes a thing,
But the actors then are being given the right through the legislation to be able to earn from that.
yeah.
Yep.
However that's negotiated or whatever the system is, that's the system that will be decided through regulation.
And
So
that
that we
is
can
that
then
is
see
in
what
the bill
happens.
already. Thank you to the panel. We are open for Q&A for the next 20 minutes. David?
So, I had one question that came up from when you were talking earlier, and it was a bit of something that I noticed is a bit paradoxical. So, you were talking about the SABC before, where to get 3 minutes of footage costs close to 200,000, you were saying,
Yeah.
something like that. And I assume that's not just for news stuff; that's for television shows and everything else, right? It's the
Yeah.
same sort of
Yeah.
price range. So, on one hand, it's incredibly expensive to get access to this stuff, but then on the other hand, the creatives involved don't make any money from it. How does that work? What happens to that 200,000 rand?
Well, this is our battle, wasn't it? It's like the Anglo-Saxon system is who commissions owes. So if you pay for a work to be commissioned under that Anglo legal regime, you don't have any rights within it. All the rights go to the person who's paid you for it. Where really all they're doing is paying for the production of the work. They're not paying for the intrinsic intellectual property that's gone into creating it. So our argument was, and remains so, that the creator the default rights in copyright has to go to the creator. Now the new act is a compromise between that. It says, well, if someone commissions you, you now have to negotiate a contract around the intellectual property inherent in that work, in the hope or with the intention that you earn something from that intellectual property right. And selling the archive would actually be part of that. But I would argue maybe we should have a different system where that archive actually is part of the public, is a public good, is part of the commons, that anyone could access it if it's being funded, particularly in the instance by a public broadcaster with public money, with people's money, that should be accessed for recreation. I mean, this is what young people are doing now. I mean, this is what you guys are doing. You're recreating, you're mashing up, you're transforming work. And that's got to be brought into the mainstream, and so it can be monetized.
Anyone? Except David? Yeah, at the back.
Okay, I have two questions.
Sure.
Like 2 points. With regards to residuals for the actor, right? And I'm going to play devil's advocate over here, right? And I'm going to speak about the producer as entrepreneur, right? Now, and especially the independent producers, right? Now, if you are trying to make a film, for instance, right? Now you have to get funding for that from investors. And if you are going to, now, we're operating under the assumption that the film is going to do well. But making a film is a risk, right? Now, the problem with residuals and feeling entitled to them is that, well, we're operating under that assumption, but you're not sharing the risk with the producer, right? The actor can easily go off if the movie is a failure to go do something else. However, if you're a producer A, you probably owe money, or your reputation is on the line. However, the actor does not share the risk at all. Now, what the actor is, to some extent, is somewhat of a commodity in the way that a worker or machinery is a commodity in the business, right? So you pay it off, right? And if it does well, you keep all the profit. Now, I'm very much for the actor being able to be put in a position where they can negotiate, right, for residuals. That makes sense. But for it to be mandated by law when they don't share the risk, well, that doesn't necessarily seem fair, especially if you're an independent producer. Now, if you're Mnet and it's a chemical or you have, right, then you have guarantees because you have a distributional channel. But if you're just making a film straight out of Wits and you're putting it on Netflix, right, it's just a platform. There's no guarantee it's going to make money. So why is that doesn't have to fit entitled to it? So that's my...
I absolutely agree.
You have a question?
Can I just jump in?
Well, yeah, we'll give our panel a chance first before you go in there. Carlynn, you have a response to this?
So one of the things I think that is a misconception is everybody thinks that they're going to have to pay actors even if they're not earning money from it, which is not my understanding. My understanding is you sell it on and you're getting money for that project. So you're selling it to Netflix. You're getting 5 cents from that sale. 2 cents is going to be split amongst the actors of the 5 cents that you're earning. So you're not being expected to pay actors for money you don't have. If you're getting paid for the exploitation of that film, you share that with the actors. So the actors are not asking you to pay or to basically give up the ability to exploit it because you owe them money.
Okay,
Do you understand what I'm saying? So when you sell it, you're going to earn 10 Rand, and one of those rands is going to be split amongst the actors.
Okay, let me answer this question. Because look, for me it makes sense, right? Because if you're an actor, right, and let's say you have a brand, like your name, right? If you're in that position, you can negotiate for a high pay, right? And you know what? And then you can say that, you know what, as an actor, perhaps it's incumbent on you to work on your brand, right? But and that makes sense because that okay, first we can negotiate, right? But on top of that, is your claim that once you're paid on set that once off you, on top of that you still want residuals from the film?
So let me explain to you a little bit around what
There's a lot of actors in the room.
What the legislation currently is proposing is that it steps in line with the Beijing Treaty, which I alluded to just now, which basically gives you the right to get paid for various platforms, various usages, broadcast, rental, communication to the public, and making available. So what it does is it suddenly opens up that you will be paid if your work goes onto a streaming service, video on demand. You'll get paid if it ends up online. You'll get paid if it gets broadcast. So where in South Africa, when, for example, you work for say it's a SABC production, when you go on, you get paid for the day. Should it be repeated, you should be paid for repeat fees, and should it get sold, you should be paid for commercial exploitation, because it takes that further. The Beijing Treaty says that your payment for the day is your payment for the day. It is not for the exploitation of the work. The exploitation of the work will depend on where it is being used. If, for example, that project is only going to be broadcast, then you get paid for broadcast fees. If that project is going to be broadcast and it's going to go on to whatever rental VOD kind of platform, then you get paid for the broadcast and you get paid for the rental. if it goes onto streaming. Then you get paid for the broadcast, you get paid for the rental, and you get paid for the streaming. So it's going to be based on what kind of exploitation are you being paid for as the project. So the project is earning from broadcasting, from streaming, from rental.
But
So-
there is still a lot of flexibility.
Correct.
So, you know,
It-
the
not
onus
necessarily.
is the contract. This needs to be part of a contractual negotiation.
There are two parts of
Yeah.
it. The one part of it is absolutely there needs to be contract. The problem with that is we have current contracts in place and none of them are honoured. So the copyright can change, the regulations can come in, do exactly what they're doing now, and it changes nothing for the actor. So part of it, which is contentious for many people, is that a part of it has to be statutory.
Yep.
There are certain provisions in a contract that have to be there.
Yeah.
Yes, we can negotiate all other kinds of terms, but in terms of actors earning from the exploitation of work, part of it has to be statutory, and that's why we are in support of the bill, because it's not enough to rely on contract.
Yeah.
Yeah.
It
Well,
hasn't
what
worked for how
I'm
many
trying to
years?
say is, I mean, what happens is, and you see it in American films, European films a lot, is a big actor really likes a project, really likes the part, will say, okay, royalties are royalties, but really, I want to be, I'll half my fee, and I'll become an exec producer. So I will get, they are taking the risk. So that is what's actually happening. Other people will say, well, you know, I'm doing something which has very little commercial likelihood of commercial success. It's deeply political and so on, it's for a niche, small audience. I'm going to find a like-minded cast or, you know, lead cast who are going to say, you know, we need to do this film just to get it out there, to get the work out there. And they're going to enter into a contract because
I agree with the content.
they agree with the content and they come in with very little money, but you may say, okay, there's always the possibility
I think the one thing
that it will make money, so you've got to then give them a bigger slice of the back end,
Yeah.
you know,
But I think one of the
or higher
things-
royalties.
one
I'll
of the
take your
things
point,
that-
Colin, and then Nontando, if you have something to add to that, it's already been, okay, thank you.
So one of the things to add is a lot of people are naysayers are saying that, you know, they're not going to be able to buy out work up front and they're going to have all these royalties down the line. And part of the freedom to contract is that it either has to be royalty or equitable remuneration. So equitable remuneration means that you can negotiate upfront for the royalties for the usage. So I'm going to get paid my daily rate because I'm going to be on set. And then a part of my global deal on this is going to agree that I get an upfront payment of the use of this and this and this and this. Whether you make squillions of money over and above that, that's yours. But we've agreed that for this project, I will agree to the following in addition to my performance fee. The problem up until now has been I'm getting paid and then I'm walking away. I'm going to get paid and I'm going to get paid additional for the use in the following areas. And I think that is important for people to realize and for actors to realize that you may not necessarily be in a position where you are going to be earning royalties down the line because you've agreed to the contract that includes an upfront payment of the usage of your work, separate from the performance.
The quick analogy there, for me as a small production company, is to fight, and our big fight is always to retain the IP in the project. So over a year, we've got 10, 15 films that are still circulating, doing something. You know, we get 500,000-600,000 round back. That pays, a big chunk of the bills, the company bills. So it's about recognising your intellectual property and holding on to it as much as you can.
One final, I'm going to take a question here from my friend. A final point on that, though, is it would be a mistake to build an analogy between the performers that you want and stock or property that a business owner might have, which was inherent in something in part of the question. When you, as a producer, decide to embark on a production, you want it to have the best chance of success. As you said, you take the risk. In that process, you will look for those people who will deliver those characters, who will draw an audience. And that's one of the ways you try and build a profit into the exploitation of your work. So it may be tempting to take the actor and say, this actor in this production means the same as the printing press in my, in my printing business. So remember that the actor is the one that you seek to create that audience who are paying to come and watch
to transform the script.
That's right.
Yeah, well, you can have a great script if you can't have people deliver on it. It's nothing. So they are it's intrinsic part of the value chain, the value that's being produced. You know?
The question you asked was a big one, and I think the extent that we've covered so far covers many different elements. I hope you don't mind, but I'm going to move to this question. And
so, Jack,
with our final... Oh, hello. Okay, you got the last one. Yes, thank you very much. Yeah.
I just want to ask Carlynn, right?
Yeah.
Yes, you always talk about audio visual.
Yes.
Is photographic imagery also part of the amazing world? Because pictures, models, and all that.
Photography absolutely is a whole nother section, and I know that there was an incredible presentation done to the portfolio committee by
Jeff Kirby.
Who is an amazing photographer, and he actually presented the one day, and the next day we were in Parliament, and the portfolio committee was still speaking about his presentation because it was so powerful around the rights to photography. So there is an entire section, absolutely. What it states, I couldn't tell you. It's not my field of expertise.
Jace, you don't have any recollection of what it's in the bill about photographers, do you? All right. Yeah, sorry. So we know it's in there, and we know that we can possibly find. I don't know what's in there about models, but we know that we can possibly get a copy of the bill in its current form if you connect with us or connect with Malibongwe, who we'll see shortly. We're going to take this final question as we wrap up.
Firstly, thank you so much. I think everyone here understands the value of what everyone is doing. So,
thank you.
Thank you. But I want to find out, just because obviously with the PPA we focuses more on residuals and royalties and the post-production. So pre-production, at least within the production phase, what are the odds that, or what are the chances that this will affect your call rate? Because you already know the call rates in South Africa are shoddy. They're shoddy, they're shocking. Is there any way that it will affect or create some form of standard or bar of a minimum rate that an actor gets to begin with, so that they're able to negotiate the post rates? Because we're looking at actors getting 800 Rand a call in 2019 versus 50,000 Rand a month on a global call. So what are the odds of that being negotiated so that we can move forward thereafter?
So I think the important thing to realize is that the legislation shouldn't prejudice further. I mean, that's the aim is the legislation is to expand. So one of the things that becomes tricky is the fact that the industry is not regulated currently, and through regulations we want to be able to find that very fine balance between protection within statute and the freedom to contract. The important thing, and I'm going to speak from a purely personal point of view now, I cannot agree to rates getting less when legislation comes in. It is impossible to allow that to happen. There are suggested guidelines that anybody who has an agent that is a professional performers agent, like a member of SAPALMA or PMA or any of those, none of them will allow those rates to go down because of legislation.
I mean, the key thing, I think, is if we are able to get the sort of money that we need as artists inside our collection management organisations that are run and controlled by us and act in our own interests, then we'll be able to build proper unions. And that we unionise this industry. And therefore there's a call rate, and everybody, you know, you don't get away with not paying that call rate if you're in South Africa. If you want to pay less, actually go to Botswana, Zimbabwe or Mozambique or something.
Yeah.
If you want to, you know.
It also is about actors standing together. And as much as currently we can't unionize because, you know, we're freelancers, there's nothing to say that you cannot stand together. I mean, that's part of the reason why Saga exists, is because collectively we have to have a voice. And each and every actor is responsible for this industry. We have to leave it in a better place than when we found it, and that is my personal mission. It's my personal slogan, is you have to leave it in a better position. So you can undermine the other person by accepting money that's less, but you know what, next week somebody's going to undermine you. And that's unfair to everybody else. We all have to take responsibility for our
I'm sorry, I mean, in America, so you don't, unless you're in the, you know, it's unionised, unless you're in the Directors Guild, you don't get a director's gig on TV.
Sure.
Unless you're in the Producers Guild, you don't get to produce the film and stuff. I mean, that's the way we need to go. And I think we need the powerful lobby of a collection management organisation to be able to assert that.
Where is Malibongwe? I need him to do a vote of thanks. While he's coming up here, I know that hand has been up just to wrap things up. What's your question?
My comments and question are actually in relation to what Hans was talking about now. So here's the thing, I just recently got casted in a drama series.
Nice work.
I have not yet signed the contract, so there's a whole lot of hectic stuff happening.
Yeah.
First and foremost, my agent does not agree to the fee that I'm supposed to be getting, right? Here's the thing. First, I saw the contract. Sometimes they get like, I have to report to work 6 times a week. I looked at the importance of the character and the story. I looked at the channel in which the drama series is going to play on. But if you look at the fee, I know also the standard rate for an actor, especially for a junior level, right? And I can assure you that they want to pay me weekly, and it's not even half of what I should be, half of the standard rate. And for the 6 days that I will be reporting to work, I'll be getting something equivalent to 2 days rate type of thing. So we're still negotiating that, and these guys are not budging. So I suppose my question is, in such instances, where does one go? Is Saga the go-to place? And here's one thing that I was told, that if I don't agree to what they're offering, we can just take someone off the street.
They will?
You know, that's what we're told. So how do we then also make sure that we put the law in a position where it's going to actually support the actors?
That is a wonderful question. I'm going to ask Carlynn to respond, and with that we'll wrap up, and I'm going to ask Malibongwe to come up to do our vote of thanks.
So the tricky part here is that the power base currently is out of whack. The broadcasters hold the power. The producers are squeezed by the budgets that they get from the broadcasters. And often the broadcasters determine the rate, not the producers. Because the broadcasters go, you can't take money from here to pay over there. You have to have a line item, and in the line item, this role, you pay the mix. So that often is what happens when it comes to broadcasters. So the fact is we end up being put in the situation where it's a take it or leave it. And that unfortunately is where the power balance currently is out. And that is what we are hoping that the regulations will address, is that there is going to be a certain standard under which people have to operate, so that as actors, we are not continually going to be the ones at the bottom of the chains that are being exploited, but that we will have some kind of an equal say. In your specific case, I'm really sorry to say, but it's going to be a bun fight in terms of you're going to try and get the best possible deal, and yes, they can turn around and they can cast somebody from wherever. And at the moment, that unfortunately is their right.
Please don't post anything on social media about your contract, your negotiation, the set, your fellow actors.
The producer, the project, the anything.
Yeah. Thank you, everybody.